Hello, everyone, and welcome to New Year, New Policies. What better way to greet 2022 than by finally tackling that thing that can live for quite a while on all of our to-do lists, getting those multi-state handbooks up to date. My name is Amy Mendenhall. I am a principal in Littler's Washington, D.C. office, and I'm joined today by my colleague Alecia Winfield, who is a shareholder in our LA Century City office. All right. Now, Alecia is going to really dive into the substantive content and let us know what updates we need for our handbooks in 2022. But before she does that, I would like to start by introducing everyone to Compliance HR's Navigator suite. Now, Compliance HR is a joint venture between Littler and Neotologic, meaning that it can leverage the legal insight from Littler and the cutting-edge AI technology from Neotologic to provide a user-friendly application to support really almost every facet of HR and employment law. Now, today, within that suite, we're really going to be focusing on the Policy Smart application in particular. So for reasons that are only going to become more apparent to us as we get to listen in on today's program, Policy Smart is Compliance HR's most heavily used tool. This platform provides a library of handbook templates with policies and checklists that cover federal, state, and even those pesky local requirements. So these templates are also accompanied by Littler guides, which provide up-to-date summaries of the law in each state. So that helps you understand the legal obligations behind those policies and also have a sense of some related compliance to-dos like record keeping, notice posting, and different aspects of even administering those policies. So, these handbook templates can help you craft a compliant handbook, but of course we know that with the pace of legal change these days, an updated handbook can become out of date in the blink of an eye. So Policy Smart also looks forward, notifying you of changes in the law that can impact those employee-facing policies. And it gives you timely summaries and template language to work with. There's also a compliance timeline that lets you keep track of effective dates of all of those new laws, as well as a report that arrives in your inbox twice per month, letting you know about those legal changes that can impact your handbook, and then reminding you of laws that were previously enacted, but hey, now they're taking effect in the current month. And we all can use those reminders. So as we can see on this slide here, labor and employment law is changing everywhere and all the time. And again, we're going to spend the next hour just really kind of wrapping our arms around both the scope and the specifics of that. If you're part of a multi-state company, keeping track of all of these changes can be incredibly difficult and time-consuming. So as Alecia fills you in on all of these potential changes to your handbook for 2022, you might be asking yourself, well, how am I supposed to keep up with all of this change and keep our policies up to date as well? But luckily, you have an opportunity to receive free trial access to Policy Smart, and just log in and you can see for yourself how it can be a really invaluable time and sanity-saving tool for tackling this, what can be a pretty enormous challenge of keeping that handbook up to date, or maybe looking back and getting it up to date. So as you can see here, you can receive a demo and a free trial of the Navigator suite, including that Policy Smart. To do that, you're going to want to just email freetrial@compliancechr.com. Or you can go to compliancechr.com/demo. You'll see that link on the slide. It should also be popping up on your screen right now. So just gather that information and definitely make sure to take advantage of that trial. Before I kick it over to Alecia, I just want to show you one specific post in Policy Smart that I think really speaks to our program for today. So in this post, earlier this year, we provided a list of every policy template we created or updated during 2021. You can see it's broken down by jurisdiction, and it has these links that then would take you to summaries of that new or amended law, as well as redlined policy templates or brand new policy templates. And notably, when you look at this post, you'll see there were 59 new or updated policies required just to keep up to date on a 50-state scale in 2021 alone. So when you do take advantage of that free trial for Policy Smart, I encourage you to come to this post, both to give yourself a nice checklist of all of these updates, but also to give you just a good sense of the scope of the resources that are available to you on Policy Smart. So make sure to check out that free trial, and when you're in there, this post in particular. Now, to help us dive into this, all of these many updates and face 2022 with fresh eyes and an up-to-date handbook, I'm going to now turn it over to my colleague, Alecia. Hello, Alecia.
Hi, Amy. Thank you so much for that introduction to Policy Smart and all of the wonderful offerings. So I just want to take a moment to introduce myself. I don't know what Amy may have mentioned about me at the introduction. I had a little bit of a technical issue at that point, but I did want to let you all know that I am a shareholder in Littler's Century City office in Los Angeles. And one of my main focuses is I'm a core member of our Compliance Audit Services Practice Group and are a core member of our Wage and Hour Practice Group. And I spend a lot of time working with companies on, getting into compliance in various areas, and working with our handbook group and Amy on, helping keep our policies up to date. We have a jam-packed agenda today, as you can see. Really the purpose of this presentation is to get you all thinking about, what handbook updates you may need to make. Hopefully some of you have already started to do some of them, but if not, this presentation will hopefully get these things to the top of your to-do list. And so it's important that you understand that, because, there probably isn't going to be a whole lot of time for me to take a, extreme deep dive into some of these updates. But, Littler has lots of materials on our website in terms of our articles and, other webinars that we have done that may go into more detail here. And, if you reach out to me, reach out to Amy, we'd be happy to point you in those directions. But I'm going to go ahead and jump into this agenda. As you can see, it's very heavily focused on updates to various leave policies, and so we're going to spend a lot of time on that. But we're going to cover some other areas as well. So first up, it's hard to do any sort of update without first touching on COVID-19 updates. So, last year we saw the federal government roll out 3 separate vaccine mandates. OSHA mandated vaccines on testing on employers with more than 100 employees. And the White House mandated vaccines on employers who worked for federal contractors. The CMS mandated vaccines on employers who receive federal Medicare or Medicaid funding. But, of course, by year's end, all 3 were challenged. And so, as of today, only one rule stands, and that's the one for employers who work at workplaces that receive federal Medicare or Medicaid funding. So you can implement your own vaccination policy, but, if you're not covered by this, mandate, it's no longer required. But be mindful, there are local jurisdictions like in New York City that have vaccine mandates. And there are certain sectors like healthcare or state employers that are under local vaccine requirements. And we are likely to see more things passed at the local level. If you are under the CMS, there are certain deadlines in place, and you can see that, one of them, there's actually an extension that was provided to employers in those states that were originally under an injunction, but even, that's starting to come up. So even though it is CMS's express position that its rule preempts any state law, be sure to check your local jurisdictions. Just because CMS provides for preemption doesn't mean that a state might not have an additional requirement that you must comply with or conflicting rules that you should be aware of. So does this mean that OSHA is out of the picture? Well, absolutely not. Just because there is no OSHA mandate, it doesn't mean that OSHA is out of the picture. OSHA's General Duty Clause requires that employers identify and correct any health or safety hazards, even if those hazards aren't covered under an existing OSHA standard. So just because there are no Fed OSHA COVID standards doesn't mean that you have no obligations to provide a safe workplace. You will need to conduct hazard assessments and document that you're doing what you can to mitigate workplace COVID transmission. And states with their own plans like Cal OSHA or Washington have their own COVID requirements. So do local health departments. So you have to stay up to date on what rules apply in your location. So we're not out of the woods yet. And also I want to give a quick spoiler alert for those of you with operations in California. Yesterday, the California State Legislature passed some amendments to the supplemental paid sick leave statutes, and we expect the governor to sign those very soon. So stay tuned for more updates in that area. I don't know why I keep hitting the slides going the wrong direction here. Got my cursor in the wrong spot. So on to wage and hour. And wage and hour is my personal favorite topic. I know that may seem hard to believe. And while I know this should go without saying, every year, believe it or not, I talk to at least one employer that forgot to take notice that the minimum wage in their state or local jurisdiction went up. So I'm reminding you now that the minimum wage has gone up in all of these states. And remember that certain states have, different minimum wage levels for employers of different sizes, like California. And, Minnesota's rate varies based on the gross sales of the business. And in New Jersey, it varies by industry. So it's very important that you, monitor all of these areas. And let's not forget about those local minimum wage rules that can vary by city, county, or local ordinances. The states with an asterisk here on this slide have implemented, have those sort of, local minimum wage rules that you, want to make sure you keep track of. And just note that this information can change rapidly. It's important to, to routinely check for these updates. I normally recommend that employers, check for minimum wage updates at least twice a year, once around the beginning of the year and then once towards the middle of the year. Some updates can occur at that time. And let's not forget that increases in the minimum wage for non-exempt employees also have the effect of raising the minimum wage for exempt employees in certain states, like California, Colorado, Maine, New York, and Washington. If you practice in California, we have the salary basis test that requires exempt employees to be paid at least twice the minimum wage, and then the computer software exemption follows its own schedule, and we see that as well in Washington. And in New York, employees in Nassau, Suffolk, and Westchester counties have to earn at least $1,125 a week, and everyone else in all other counties, the rate is different at $990 per week. So be aware of that. And if you want more of a deep dive into these increases, Littler published an insight on the minimum wage that you can check out for more information. So for those of you that apply tip credits, and if you are in California, that's a big no. You can't do that in California. But if you are in a jurisdiction where you can apply tip credits, it's important to be aware that the Department of Labor has resurrected the so-called 80-20 rule that governs how tipped employees must be paid. Now, it's been resurrected with some modifications, and so under the revised rule, tipped employees are, divided into, three categories. You're looking at those who are doing tip-producing work, directly supporting that work, and work that is not a part of a tipped occupation. And depending on the time that they're spending, you may or may not be able to apply the tip credit rate to that work. So it's important that if, you are applying a tip credit, that you are aware of and reviewing your policies against, this Department of Labor update. I also want to remind you that the Department of Labor has broadened the joint employment standard under Biden's administration, and so that means there is a higher likelihood that a company will be deemed a joint employer depending on the extent of control and supervision it exercises on individuals that are technically employed by other companies. So this tends to be a big area to take a look at for staffing firms, subcontractors, franchisees, and company, affiliated companies may want to take a look at this and how it may impact them. Now in California, intentional festive wages or tips by employers is punishable as grand theft. It's not yet clear how intentional, quote unquote, intentional wage theft will be fined or construed under the law, but it's important to take a careful look at your California wage and hour policies and to provide training on those policies to avoid issues. And I should note that jail time is a possibility, although, we certainly hope that would be the rare instance when, that would be applied. There are some restrictions on independent contractors that we want to, quickly touch on. New York has expanded the whistleblower protections to include independent contractors. New Jersey has increased penalties for misclassification. And in California, we had all of these various exceptions that were in place that were set to expire on January 1st of 2022. Well, the legislature has stepped in and they have expanded some of those exceptions for a few years, and they have added a few to the mix as well. So if you are, taking advantage of any of those exceptions, take a look to see if you are part of, the extension of those standards that allow you to still, fall under the old Borrello test. And it is important to remember that both the Department of Labor and the NLRB have implemented policy changes that disfavor findings of independent contractor status. So be mindful of that. It's, if you've got workers who are on the cusp, you may want to take a look at that and consider, if you want to think about reclassifying. So I'm going to quickly touch on some, changes in employment contract rules. In California, there's a new restriction on severance agreements involving workplace harassment or discrimination on any protected basis, not just sex. You can no longer, prevent the disclosure of information about unlawful acts in the workplace. And, here's the interesting thing that I think completely new is you now must notify employees of their right to consult with an attorney and provide a reasonable time period that's not less than 5 business days for them to consult, regardless of their age. So, if you've had these agreements in place before, that we had some similar provisions for individuals that were over the age of 40, but now, we have this for everyone. Alabama is that has set some standards for creating non-disparagement agreements. So if you have operations in Alabama, be sure to review those new standards. In Oregon, the definition of protectable interest required for a non-compete agreement has been clarified. The duration of non-compete agreements has also been shortened to 12 months from the date of an employee's termination. Washington has increased the earnings threshold for non-compete agreements to be enforceable. And, we have the ongoing issues in California with mandatory arbitration prohibitions. So in light of the Me Too movement, several states started to beef up their requirements for anti-harassment policies. And, some of this can really create headaches for employers that are operating nationally. If you haven't had counsel take a look at your national handbook policy recently, you might want to think about doing so. Some of the things to remember and to keep in mind, when drafting a national harassment policy is you definitely want to make sure that you include these items: federally protected categories. You need to include conduct that does not rise to the level of unlawful harassment, in part because, we don't want our employees to be engaging in, behavior that rises to the level of harassment before it gets addressed. So you want to make sure you've got some things that are less than that, but are still prohibited. And you also want to include examples of sexual harassment. It's really helpful to illustrate the type of conduct that the policy is designed to prohibit. So providing examples of what physical harassment is, verbal harassment, nonverbal harassment, those sorts of things. We'll also want to include other types of harassment. We're not just concerned about sexual harassment. Harassment can be based on any protected category, such as race or disability. We also want to include that retaliation is prohibited in every state. So we want to make sure we have an anti-retaliation section in any policy. And then we start to think about, we have to start thinking about what state-specific requirements do you need to include. So, for example, if you have operations in New York or California or some other states, require some specific information be included in the policy that pertains to, the complaint procedure. For example, this is the contact information to your local EEOC office. And you'll also want to include, for certain states, information that pertains to investigation and discipline. And you'll want to make sure these special requirements are included in either the national policy, if you're going to go with that, or in the applicable state supplements. And you also want to be sure to carve out protection for good faith complaints, even if they turn out to be unfounded. So, here's your checklist for states that require additional language for state agencies or other special language. And, you should work with counsel if you operate in any of these locations, or, I know, Amy's got all this information well tracked as well in Policy Smart. We also recommend getting an acknowledgement of the policy. You want to make sure that employees sign off on your anti-harassment policy, because you want to make sure that, they have read the policy, they understand the process, and they understand where to go if they have needs that need to be addressed. Okay, well, several states have passed new laws concerning protected categories. Some of you might remember that a few years ago, California passed the Crown Act that prohibits discrimination based on hairstyle and hair texture. And as you can see here, we've got a number of states that have, passed similar protections. And, these protections vary, slightly from state to state. Some mention hair texture, protective hairstyles, and even skin color in Nebraska. So this might be a challenge if you're trying to put all of this together into a single national handbook. And so if you've got, operations in several states and you don't use state supplements, maybe, the point in time where you start thinking about doing this is we have all of these, various different requirements that you have to meet. And, there are risks, if you try to combine, some of these things into a single policy. We've been advising employers to be careful that you're not somehow defining a right for someone in a jurisdiction where that right doesn't exist by having it in your policy. So we generally recommend, adding some of these specific things in a state supplement, and also, of course, working with managers to make sure that they understand the new laws and the details of those laws. You may also want to take a look at your dress codes, and make sure that they are not somehow inadvertently prohibiting something that is now protected under the law with respect to, hairstyle discrimination. Okay, so in Pennsylvania, passed discrimination based on military status. They've made some updates to their law on that, or membership in the National Guard. That's now protected under that law. Virginia now has a law that prohibits discrimination based on an employee's active military status or their spouse's status. Some other protected category developments include Colorado has expanded its law to include gender identity and gender expression at the state level. Illinois has added work authorization, and Maine now prohibits discrimination from seeking protection from abuse and on the basis of familial status. So every year there are a few updates in the lactation and pregnancy accommodation world, so we'll go over some of these. Most of you know that under federal law there is some protections. It's usually not as detailed on the things that most state laws provide for. So be sure that you're also checking for requirements within your state. So, for example, in Connecticut, a refrigerator needs to be provided in the lactation room. That's a new requirement. Indiana has a new law that requires employers to respond within a reasonable time frame to a request for pregnancy accommodation. In Louisiana, there's a new law that says 6 weeks of time must be provided for most pregnancy disabilities and up to 4 months. In Minneapolis, the law was amended to require paid lactation breaks and require employers with 15 or more employees to eliminate the length of service hours and hours worked requirements for eligibility. So I think, as I mentioned at the outset of this presentation, leaves of absence is going to be a big focus for anyone looking at updating their handbook this year. But, we want to start out by sort of giving you sort of a bird's eye view of, where things, basically stand, right? The majority of states don't have any paid family leave programs in place. Those are the states that are in teal, but, we can see that, this is shifting. The green states show states with paid family leave laws that were in existence prior to 2021, and the purple reflects states with new laws that are coming into effect. And given, the impact of the pandemic, I don't think it would be surprising to see more and more states turning purple over the coming years. So currently there are programs in California, New Jersey, Rhode Island, Washington, D.C., and Massachusetts. Connecticut's law is now also in effect. Contributions began last year and benefits became effective this year. And these all cover family member care and bonding with new child leave. Some of them cover employee illness, but some have a separate statutory disability program for the employee. Some cover family military events under the FMLA. Now, most of these plans are structured as statutory insurance programs that are administered by the state or a private insurance company. And then we have some new laws coming into effect in Oregon, Colorado, and New Hampshire. So, here are some key points for the new law that's coming to New Hampshire. We want to point out that for this law, when it comes into effect, it will not be required to appear in the handbook, but you'll want to be familiar with the law when it goes into effect in 2023, even though you're not required to have the written policy in the handbook. These are the requirements for Oregon. Again, the benefits will start in September of 2023. It's also not required to appear in your handbook, but there are some notice requirements that apply with this change. In Colorado, benefits will start in January of 2024. Again, it's not specifically required to appear in the handbook, but you'll want to be familiar with the requirements and ready to roll it out once the rule goes into effect. One more point that we want to highlight, there are some states with separate disability insurance programs. You may want to make a note of this. And I see that someone put in the chat asking if we're going to talk about the new California paid sick leave law that was passed yesterday. I made a point about this at the outset of the program. Yes, the California State Legislature, signed a new law yesterday. The governor has not yet signed it. So we will be, sending out updates on that when we have more details. I do not have time to go into that in substantive detail today, but look out for it. We are working on updates now. So now I want to move on to parental leave. This, again, is a very big trend that has been taking off in the last few years. And we're certainly going to highlight some things that you need to be aware of. But before we do, we wanted to do a quick poll to find out if your company is following the trend that we're seeing. So we have a quick polling question for you. If you could, please answer it. And the question is, has your company implemented a paid parental leave policy in the past 2 years, or do you currently have plans to do so? So, Amy, I don't know, what you think. Do you want to wager a guess on what these percentages might come in at?
Oh, let's see here. I'm going to say 43% say yes. What do you think?
43. I think you're right. I'm thinking around the 40% range makes sense to me. And let's see. Are results ready? Oh, the data's still flying in. Oh, wow. Okay, well, so I guess we'll give it a couple more seconds here. It's interesting. I really think it's a really great development to see more and more companies that are willing, to do this. Wow, and data is still flying in. I think at some point we're just going to have to go with what we've got. I wonder if the percentages are going up and down. Can we get the results, please? Oh, I'm sorry. I was supposed to close the poll. So the poll is closing in 3, 2, 1, and hopefully we'll get the update in just a moment here. I don't know if I've messed this up, Amy. Oh, okay. So we've got the results. So we got 47% of you say yes, and 53% say no. So look at that. We're getting really close to the 50-50 mark here. I think that's really exciting. We'll have to see what happens in the coming years. So if you are, one of the companies that are in that 47% range, or if you want to implement a parental leave policy, there are some things that you should think about. So, one, traditionally, I think we've all thought of this as maternity leave, but the EEOC has come out and said that, if you give women time off to bond with their child, then men need to get the same benefit. And, this, of course, all makes sense. It's only fair and equitable that men need time to bond with their child as well. So it's important to be very mindful about what our assumptions are when that we tend to carry around about gender roles in this, particular area. So you are able, though, to give extra time off to the employee that is actually giving birth. The EEOC is fine with that, but you need to be careful when you're drafting your policies. It's popular to refer to the primary and the secondary caregiver in policies, and to provide more leave to the primary caregiver and less leave to the secondary caregiver. But don't fall into the trap of assuming that just because someone is female, they will be the primary caregiver. Also, some companies have moved to offering just bonding leave that, they say everybody can get the same bonding leave, but you can run into trouble if you have short-term disability that runs concurrent with the bonding leave. And in some instances, the birthing parent can end up with less leave than intended. So there are some risks there. So, when implementing a parental leave policy, we recommend establishing two buckets. The first bucket will be, for time for postpartum disability, and this is going to be for the birthing parent. This is medical leave for recovering, that needs medical leave for recovering from birth. Typically, we're talking about, 6 to 8 weeks of leave, and this time can be coordinated with short-term disability. And the other bucket we have is for the bonding leave, and that is available to, for everyone to bond with their newborn or newly placed child. The company can select the number of weeks it would like to offer, but you want to be careful that you coordinate with any state laws that may be on the books. So we highly recommend that any time taken under the parental leave policy will run concurrently with federal and state programs to avoid stacking. You don't want your employee to say they're going out on the company-provided leave and then later say they're going to take the California leave that is available to them. You also want them to apply for any state benefits they're eligible for. All of this is something you definitely want to consult with experienced counsel on in your jurisdiction. It could be very complicated and can be overwhelming, so you may want to loop counsel in to help you navigate these issues. And some additional, best practices. Many companies don't like parental leave to be taken intermittently because it can be such a headache administratively to manage. So you can mandate that the leave can't be taken intermittently, or you can limit the size of the incremental leave, such as saying you have to take it in 2-week chunks. You can certainly ask for a notice period, but obviously be mindful that there are times that much notice cannot be provided. And there's some, other important legal disclaimer stuff that you'll need to include. So please loop in knowledgeable counsel to assist you. So now I'm going to talk about some, mandatory, paid sick leave. Now, at the outset of my practice, Goodness. I'm not even going to tell you how long ago that was. The number just flashed into my mind. At the outset of my practice, though, sick leave was, really a matter of choice for employers to provide. But, we all know that times have changed, and now sick leave is a matter of statute in a number of places. And there are, in the last 12 months, we've seen even more, places adding to this list of, changes and making changes to existing obligations. So you can see some of them here in West Hollywood and in other areas of the country, in Pennsylvania and New Mexico have, added to, they've implemented new paid leave laws. We have more requirements. Here are some in Chicago, in Minnesota, and in Oregon. And it's interesting that, some of these changes that we're seeing with paid sick leave laws don't always have to be for a health-related reason. For instance, interesting fact about the West Hollywood ordinance, it basically provides paid leave for vacation or personal necessity that isn't defined. So the law really acts more like a mandatory paid time off law that, gives employees a bank of paid time they can use for, personal necessity reasons. We're seeing some companies looking at implementing unlimited PTO programs. This may be, because of, all of these new leave laws on the books. Employers are, tired of trying to keep up with all of this stuff, and they're wanting to, move some of these PTO balances off their books. But, there's some, risks to be mindful of before taking this approach. Make sure that you pay close attention to the laws in your state. Because, cash out of accrued but unused vacation is required in some states. And so you'll have to think about how you will deal with this with an unlimited PTO policy. Also, how do you integrate it with all of these other leaves that provide for, unpaid leave? Do they now get shifted to becoming paid leave? These are, questions that you're going to want to ask. And then there is another problem is with military leave. So USERRA provides 5 years of protective leave to serve in the military. So if you have unlimited leave, how does this line up with your policy? Now, we certainly have clients that have gone, in this direction with implementing these unlimited PTO policies, and we have attorneys that can help provide advice and guidance. But, the point here is that, this is an area that can be a challenge to navigate. So, make sure that you're looking very carefully at it. I also want to highlight a few things with an amendment to USERRA. There was an amendment in 2021 to add a couple of items to the definition of uniform services. So if your policy is detailed and you have defined terms within your policy, you're going to want to make sure you take a look at this and include this new information. This is not new, but it's important to remember that all of these state leaves are coming down, USERRA has a comparable leave requirement. So if your non-military leaves are being provided to employees that are, similar to those that are taking a military leave, the employee on military leave has to be given the most favorable treatment provided to any comparable form of leave. So leaves are considered comparable based on the duration and purpose of the leave and the employee's ability to choose when to take it. So you're going to want to look carefully at this area as well. There are some other developments in the area of military leave in these states. So if you have operations in Iowa, Montana, Oklahoma, Oregon, Pennsylvania, Tennessee, or Vermont, you're going to want to be mindful of, these military leave updates. So, we always seem to have a number of new leave of absence laws to run through. So I'm going to go through those as well. In Connecticut, there is a new voting leave law where employers must provide 2 hours of unpaid time to non-exempt employees for voting or to work as an elector. In New York has a new paid leave law that provides up to 4 hours of paid time for the COVID-19 vaccine, and that's going to be in place until the end of 2022. Missouri has a new domestic violence leave. Employers there must provide unpaid time off of 1 week for employers with 20 to 49 employees and 2 weeks for employers with 50 or more employees. And the time off must be given for medical, psychological attention, planning for safety, or obtaining legal assistance. And notice must be provided. In Pennsylvania, we have a new living organ donor law. It runs concurrently with FMLA, and the requirements are similar to FMLA. The time off may be taken for employees, for the employee's own donation or to care for a parent, spouse, or child that is either donating or receiving. In Oklahoma, we have a new military leave law that extends protection to Oklahoma National Guard employees. And in Nevada, we have a new law that provides if an employer gives paid or unpaid sick leave to employees, they must be permitted to use the time to assist with family members' illness or injuries. And, there's also a, paid vaccination leave law in Nevada, also in Chicago, and we, of course, in Los Angeles. Now I'm going to briefly talk about some state leave amendments. As you know, California amended its law to include employers with only 5 employees under CFRA last year. There's been a slight change for 2022. Parent is defined to include parent-in-law. In D.C., the Universal Paid Leave Act has been amended to increase the amount of medical leave and also to cover prenatal leave. In Illinois, the Victims Economic Security and Safety Act has been expanded to cover crimes of violence. In Kentucky, adoption leave was amended to provide that if a company provides parental leave for first-time parents, it must provide that leave for adoptive parents also. Maine's state FMLA was amended to cover the care of grandchildren and the domestic partner's grandchild. In Maryland, the Flexible Leave Act was amended to allow eligible employees to use paid leave they have available for bereavement. In Oregon, the Family Leave Act was expanded to allow emergency and sick child leave to be reinstated for employees that are rehired within 180 days. It also expanded eligibility for public health emergency leave. In Rhode Island, the incremental increase for temporary caregiver insurance went up from 4 to 5 weeks. In Washington, the paid family leave was amended to cover the care of dependents, and temporarily expanded eligibility. Also, volunteer firefighter is included in the definition of volunteer emergency responder now. In Arkansas, employees can still store a firearm in their locked vehicle, but there is now, these are just some other laws that are interesting amendments, moving away from leaves a little bit here. So going back to in Arkansas, employers can store a firearm in their locked vehicle, but they can now ask for an exception to that law if the employee is under any type of disciplinary action. That's an interesting development and sounds like a great one. In Connecticut, employers with 5 or more employees are required to prohibit smoking inside. In D.C., employers can no longer prohibit outside employment or self-employment unless it conflicts specifically with job duties. And in Philadelphia, the city has started enforcing predictability pay requirements, which is like a scheduling law. So we have a few more laws to talk about here in terms of mandatory policies, and by this we mean that these policies must be provided for in the handbook. It doesn't mean that these are the only policies you have to comply with. So there are some new required policies. First, we have the Colorado Overtime and Minimum Pay Standards Order. Previously, this was under Order number 37. Now the order needs to be changed to number 38. So make sure that you have updated this order and that you get employees to sign the acknowledgement. It basically, codifies that vacation can no longer be use it or lose it in Colorado. There's also a minimum pay rate for sick leave that's been established and a new highly compensated employee exemption from overtime requirements. It also establishes a regular rate of pay for employees with multiple jobs. Next, we have New York with the Airborne Infectious Disease Exposure Plan. This is a safety plan that is required to be in a handbook. There are sample plans on the New York Department of Labor website for various industries, and you can also, contact us here at Littler. Virginia has a new reasonable accommodations for individuals with disabilities law that is required to be, employees must receive notice of this new law. And go on to a couple final words here. Here's a few things. These policies are not required to be in the handbook, but you should be aware that a number of states and some cities have passed right to recall laws that are primarily targeting the hospitality industry. These laws require that recall of employees in order of seniority, but they can be complicated, so it may be challenging to try to cram all of this into a handbook, but it's very important to be mindful of these laws. Also, for the first time, California warehouses now have a production quota law that's going to apply to distribution centers in California. So be mindful of that if you are, operating a distribution center in California. One question that you might ask yourself is, whether you're required to get an acknowledgement of receipt of any of these policies, these new laws, we're talking about. Here's our checklist of the new policies that have signed acknowledgement requirements. We talked about some of these, maybe not all of these. As I said, this presentation isn't fully comprehensive. We have lots of articles and information on the Littler website about all of these new laws. So if there's something going on in your jurisdiction that I did not cover, you may want to check for that there. You may also see here that the California harassment policy is in brackets, and that's because the requirement in California is really to distribute the policy. There's no actual requirement that it be signed, although, a good idea to have employees sign it, of course. And with that, this is the conclusion of our presentation on the new policy update. So, Amy, are there any questions from the chat?
Oh, yes. We've gotten a bunch of great questions. So maybe we could tackle a few that I've seen more than once so we can address as many of these as we can in our final few minutes. One I've seen quite a bit, Alecia, is how often do you recommend updating a handbook? Is annual still enough?
Wow, that's an interesting question. I tend to think most employers who are doing this regularly are probably only looking at this once a year. But what I've been trying to encourage my employers to do is to, of course, sign up for Policy Smart, because I actually think it's probably easier if you don't try to have to update every single policy at the end of the year. It seems like such a heavy lift. The nice thing about Policy Smart and the updates that you provide, Amy, is it allows employers to take a look at what's hot off the presses and address those issues as they arise. So if you're within an organization where you've got that freedom, right, where you can, work on making updates throughout the year, I think that's probably the best way to go. But I think in reality, most employers are doing it around once a year. What do you see in your practice, Amy?
I think you're right. I think, annual is probably the cadence that's still in many folks' mind. What I find with so much tracking is sometimes there will be updates within the year that are actually required to appear in your handbook. So, the law might say right on the face of the law, hey, you have to have this notice in writing in the hands of employees, or a policy in your handbook. We saw this with one of the examples you raised with the New York Airborne infectious disease policy, where that absolutely has to be in your handbook, and it's a pretty heavy lift to kind of comprehend and get it in there and train on it. And you don't get a full year to get that reflected in your handbook. So I do think, and given just the volume of what you're going to see in a year, like you're saying, it might help to kind of tackle it as things come up. A related question, a lot of folks are asking, okay, if we're in multiple jurisdictions, can we still use one national handbook? Do we need state-specific handbooks? What's the best way to tackle these state and local specific requirements for an employer who's getting to be in more than one state and a bunch of states?
Yeah, I think the most effective way to handle that is to have a national handbook with state supplements. I still think that's the best way to go. Although admittedly, the state supplements that I sometimes see in California are so robust that, it may be, something that you might consider having a separate California handbook and state supplements in other jurisdictions. I could certainly see that as a trend that makes sense as well. But do you have thoughts on that, Amy?
No, I think you're right. I think it's just getting, again, more and more challenging to have that one national handbook. I think there was a time when employers might have thought, well, if I just kind of provide the most generous, I'll be compliant everywhere that we are. But so many of these laws, particularly in the leave area, just have these really specific and detailed requirements that are difficult to meet in that way. So I think it can be really helpful to have those state supplements. And there's a certain efficiency built in there in terms of updating as well, because rather than doing an overhaul to the whole handbook, you can isolate those state or local changes. Another question that we're seeing, I see we have just a minute left, but it's related, is, every time we're seeing all these updates, 60 in a year, does the employer need to notify employees every time there's a change in the handbook, certain times, how does that work?
Yeah, I recommend, well, I suppose it really depends on how your setup is. But like, for example, like if you're rolling out new handbook changes every year, then yeah, I would expect that you want to have some record that you have notified employees of these handbook updates and get updated acknowledgments, from employees. And certainly, moving to electronic acknowledgments may make it a little bit easier to do that. I understand it's a challenge, but frankly, if you're defending a lawsuit and we can't find any record, and you went and you updated, you have this great policy, and we can't find any record that the employee actually, signed an acknowledgement that they had received it, that's a problem, and it can impact the defense of the case.
Yeah, that makes a lot of sense. That's a good litigator's perspective for us compliance folks. Great. Well, thanks, Alecia. I see we're up against our 2:00 Eastern time. Should we close out, say goodbye?
I think so. I think we just want to make sure that we mention that there is a certificate link to obtain your credit for attending today's program. It should now be on your screen, and we just want to, follow up and let you all know that we do see that there were some other questions that were mentioned in the chat. I will, receive those in the next couple of days, and I will do my best to put together a Q&A to answer, at least some of those, more frequently asked questions there in the chat. And I'd like to thank you all for attending today's program.